This is Barry Zalma speaking for the blog Zalma on Insurance. Today we're going to talk about the unmitigated gall of a fraudster to abuse an elderly bishop and his church by obtaining title to the church by fraud, which eventually was defeated in court. It is villainous to steal church property from a sick and elderly bishop who had no idea what was going on. And the California Court of Appeal, in a case entitled Testimonial, Cathedral Local Church of God in Christ versus EquityKey Real Estate Option, LLC et al., a November 18, 2025 decision of the California Court of Appeal, EquityKey, through broker Stephen Sharpe and Frank Wheaton, a trusted advisor and friend of elderly Bishop Jimmy Hackworth, presented a deal supposedly for a $4 million life insurance policy on Hackworth's life, with EquityKey as beneficiary. In exchange, EquityKey paid Hackworth $400,000 up front. To qualify Hackworth for the large policy, church real property on South Western Avenue, Los Angeles, was temporarily transferred into Hackworth's personal name with a 2008 handwritten grant deed and a 2009 printed grant deed. Hackworth, in his late 70s, disabled with hand tremors, and his daughter Angela Hackworth Wilson, the church administrator, testified they were repeatedly told this was purely a personal life insurance deal for the bishop. The church was not involved, and no lien or third-party interest would attach. Wilson signed most documents, including the performance deed of trust, the PDOT, under a power of attorney because Hackworth physically could not sign. She testified she was rushed, did not understand the documents, raised concerns, and was falsely reassured. The real estate investment agreement and PDOT were dense, small print documents that appeared to be within an individual qualified homeowner, Hackworth, but described the church's real property and gave EquityKey an option to acquire it plus a share of appreciation secured by the recorded PDOT. The church first discovered the recorded PDOT liens in 2018-2019 while attempting to refinance. It sued in 2019 to cancel the PDOT and the deeds. The trial court made findings first about the statute of limitations. Claims to cancel the grant deeds were allegedly time-barred because the church knew it was transferring its own property in 2008 and 2009. Claims to cancel the PDOT, the lien instrument, were found to be timely. The governing statute, 3 years for fraud. The court also noted the 4-year statute would apply to straight cancellation, declaratory relief, but fraud controlled here. Next, delayed discovery rule applied. The cause of action does not accrue until the plaintiff has actual or inquiry notice of facts constituting the fraud. Substantial evidence supported finding that the church had neither actual nor inquiry notice of the lien until 2018 to 2019. There was credible testimony that Sharpe Wheaton misrepresented the entire nature of the deed and the deal for providing life insurance and cash for the bishop. confidential trust relationship with Wheaton, a longtime legal advisor and church member, relaxed the normal duty of inquiry. Oral misrepresentations lulled the church into inaction. Failure to read dense documents was excusable in light of fraud in the inducement. Mere existence of a recorded PDOT in public records was insufficient to trigger inquiry notice about some reason to search title. There was no evidence that contradicted the church's witnesses. EquityKey called no percipient witnesses from the 2008 closing. The PDOT was voidable and canceled because material misrepresentations induced execution. The deal was falsely presented as only life insurance with no church involvement in the lien, and Sharpe was EquityKey's agent and bore responsibility for the fraud. As a condition of canceling the PDOT, the court ordered the church to repay the $400,000 EquityKey had paid to Hackworth in 2008 plus interest, and judgment was made cancellation effective only upon full repayment, creating an incentive for prompt payment, putting everybody back to where they were before the fraud was instituted. The key legal takeaways are: 1. Fraud claims, including cancellation of instruments procured by fraud, are governed by a 3-year statute of limitations with robust delayed discovery protection. 2. Where a confidential or trust relationship exists or active misrepresentations lull the plaintiff, the duty of diligence is significantly relaxed or eliminated. 3. Failure to read a contract does not bar relief for fraud in the inducement when equitable remedies, rescission, cancellation, are sought. 4. Mere recordation of a lien does not automatically start the statute running if the plaintiff had no reason to suspect its existence or fraudulent nature. And 5. Trial courts have broad equitable power when granting cancellation, rescission to condition relief on restitution, here repayment of the $400,000 benefit received. The judgment was affirmed in full. The church keeps its property free of the PDOT once it repays the $400,000 plus interest, and costs were awarded to the church. The Court of Appeal affirmed the trial court's judgment and canceled EquityKey's 2008 performance deed of trust, found the church's lawsuit timely, and ordered the church to repay EquityKey the $400,000 that it advanced. In my opinion, taking advantage of an ill old man and the church he served to steal the church property and get the bishop a $4 million life insurance policy that would be paid to the broker, EquityKey, and a $400,000 advance on his life insurance without having to die to collect is egregious. The court protected the bishop and his church from the fraud and used the delayed discovery rule to prevent the success of the fraud. Fraud perpetrators are people with no honor and have the unmitigated gall to defraud a sick old man to allow the fraudsters to take ownership of the church property controlled by Bishop Hackworth, who was physically unable to sign the documents. This video was adapted from my blog Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll also gain access to the more than 5,200 blog postings. Please tell your friends and colleagues about this blog and these videos on YouTube and rumble.com. They're free, and you can simply subscribe and will receive each blog posting as it happens. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publications. Thank you for your attention.